Thank you for visiting Past the Wire TV, the YouTube channel of PastTheWire.com. And welcome to another episode of Past the Wire TV. I am here with my friend and attorney, Bill Gotimer. To talk about some interesting things that are going on in the world of horse racing right now. Bill is a well-versed and experienced attorney who has a lot of racetrack knowledge as well. He's been involved on a racetrack as far back as I can remember, and I remember quite a ways back. So, Bill, thank you so much for coming on the show and talking with us today.
My pleasure, John. Always a pleasure to join you.
Appreciate that. You know, I got to say, I think we're up to 3 separate class action lawsuits filed against Bob Baffert and, all the result of the positive betamethasone test in the Kentucky Derby. And I find it very interesting, all the lawsuits on many different levels. And the first thing that I find odd from a layman's standpoint is that none of the 3 plaintiffs, and I understand there are more than one plaintiff in each suit, nobody waited for the split sample to come back. Do you find that odd?
Well, yes and no. I mean, obviously, you always want to make sure that what you're filing as a lawsuit has a factual basis behind it. Attorneys do not file things lightly. But despite some of the frivolous actions we've seen in the last year or so, that mostly were grandstanding in areas outside racing, attorneys are reluctant and really are duty bound not to file frivolous lawsuits. So typically you would like to wait until you had as much evidence as you could get. Class actions are a little bit different though, because class actions essentially are an attorney or a group of attorneys, a law firm seeking to represent an entire class of people. And the real benefit is it's a real benefit to be the first one to file. Okay. Because when it comes down to it, if a class is certified, the court will appoint one law firm to represent everyone. And of course, that's something a lot of attorneys would like to do. So being first, while it doesn't guarantee that you get chosen, it does in fact give you a leg up in the court's eyes. So class action suits are often filed earlier than other suits would be because there's an incentive to file it quickly.
I get that, but what my concern would be, and obviously I'm not an attorney, but if I was going to file a suit like that, my worry would be if the split sample comes back negative. It's a lot of egg to wipe off my face. No, as an attorney, I mean, doesn't the whole thing kind of go away if that happens?
Well, I guess I certainly it weakens your case, and it may in fact show that the instance that caused you to bring suit might not have happened. But I think all 3 of the suits speak about a pattern and a long-term pattern of activities regarding performance enhancing or prohibited drugs. So I guess it doesn't hang necessarily on the Kentucky Derby. The Kentucky Derby, I think, in a lot of these suits is sort of the straw that broke the camel's back in their mind.
So then a negative split sample isn't an automatic win for the defendant by any means. The case can go on even if that does come back negative per se.
Correct. I mean, as kids, we've all been yelled at or chastised for something we didn't do, but it was the one time we didn't do it. So I mean, I think the plaintiffs would contend that this is a pattern, and whether or not it happened in the Kentucky Derby is really not dispositive.
Gotcha. So the history of violations and all of that, everything comes into play in a suit like this.
Correct.
Okay, and that's all if I'm not using the right term, forgive me, you'll correct me, but that's all discoverable, that's all admissible, that's all part of the case. So they're going to go through every violation and basically dissect them. And
yeah, I mean, they've claimed a couple of things. They've claimed that it's a pattern and that it's part of a corrupt enterprise, and that's the RICO portion of the case. And RICO originally was probably passed in response to the typical organized crime activities, where each individual violation may not be a big deal, but when you put them all together, it's a corrupt enterprise. That's sort of what it's about. So yes, I mean, each individual, they're seeking to show that it's a total pattern of a corrupt operation.
Okay. And is the burden of proof for that to get to that RICO level difficult?
It is difficult, and class action suits, the burden of proof is more difficult at an earlier time. I mean, now, one thing to remember, John, and most people who aren't attorneys wouldn't know this, that the real difficulty in any class action suit is having a class certified.
Okay.
As a matter of fact, I mean, as a matter of practice, rather, once a class is certified, the damages can be so large that it's almost impossible to completely defend. So settlements come out of it very quickly once a class is certified. So the battle here, and the battle in any class action suit, will be to have the class certified. That's really the battlefield. That is the victory or loss, whether a class is certified by a federal judge to exist.
Interesting. And what would be like? What is that battle? What does the judge decide? What makes it a class action, or what makes it where a judge might say, no, it's not a class action? What's that criteria, so to speak?
Well, it's a very complicated thing, and it's subject of much debate and many court cases as to what level of proof you have to have for the underlying cause of action, and whether or not you have to prove it or whether or not you simply have to allege it. Typically, in any lawsuit, simply alleging it is enough to get it to the discovery stage. But in a class action, there's a little bit of an undefined higher requirement. But that being said, a class action suit is only appropriate if it fits a number of things. And the number of things, I don't want to make this a law class, it'll bore everybody, but you have to have commonality, meaning that everybody in the class is in the same position. You have to show that this is a proper way for people to be compensated, that this is the best way for it to take place. And typically that means that there's a lot of people who lost a little bit of money. So I think all of us in our lifetime have been part of a class rather, in a class action suit, whether we've known it or not. You've gotten a letter that said you paid Verizon too much, or your cable company overcharged you or didn't give you a refund when they canceled baseball.
I'm glad you brought that up as an attorney, because I did get such a letter. I signed it and I never got any money.
It's probably still working its way through. You know, you'll get a check someday down the road for a minimal amount of money. Okay. And one of the things about it is it's typically designed for cases where it's too difficult for any individual to bother. So you're not gonna sue Cablevision for overcharging you $1.75. You're just not going to do it. But right. millions of people in that situation can be represented as a class. So that's called numerosity. Numerosity means there's a lot of people who are similarly situated, who are best served by being represented by one spokesman and one attorney, who in fact will get the lion's share of any recovery. So when it comes right down to it, the biggest financial stake in any class action, other than the defendants who have to pay, are the attorneys who bring the action, because they bring the action on the behalf of everyone. They get their fee, and the rest is split among the members of the class.
Interesting. Now there's something that I thought, just as a layman, but the more I researched it, the more people I spoke to about the case, and I find it a fascinating case, because I think it sets, if the plaintiffs prevail, okay, or if the case gets settled, it sets a very interesting, in my opinion, precedent in horse racing, because that opens the door for anyone who ever lost a bet to a horse that tested positive to file suit. I mean, as a layman, that's how I would take it. I'd be like, hey, wait a minute. I lost this race to so-and-so way back when. That horse came up positive. Now, the two things I thought that might come into play, and I might be wrong, you'll correct me, is one, I know the parimutuel rules say that, you know, DQs for positive tests don't affect mutual payouts. Those are racetrack rules. So do they necessarily apply in federal court as well? That's my first question. And my second question is, would the plaintiffs have to prove, and I thought this was where the case would be very, very difficult, and maybe they don't have to prove this, but I would think, based on what I know of the case, that they would have to be able to prove, if not for betamethasone, Mandalore would have won the race. And I think that's a very difficult argument, or difficult thing to prove in a courtroom. So both of those issues, can we talk about them a little bit? One, do the racing rules parallel or spill over into the federal courtroom? Whereas, we're very sorry this may have happened, it's a racing violation, it doesn't affect you, you're not entitled to damages because the rules clearly say we make the rules and you play by our rules. Or is a federal courtroom different? And will they ever, at some point to prevail, have to be able to prove that Mandalore would have won if not for betamethasone?
Right. So to answer them kind of one at a time, you have two questions right here, and one is whether or not you have a duty to anyone, to the people who are filing suit, to the plaintiffs, and the second one is whether or not a violation of that duty caused you to suffer harm. Right. So that's the basis of almost any lawsuit. And it really begins with a duty. So if you do not have a duty to someone, it doesn't really matter what you do, right? I mean, so you know, if the classic example of, you know, someone says, please help me, I can't stand up, and you walk past them. You know, that's the Good Samaritan parable. You know, it may be immoral and it may be against principles to walk past someone, but it's not illegal. You know, you don't have a duty to save that person. You don't have a duty to help that person. So if that person were to sue you and say, I was lying on the street begging for help and you walked past me, the answer would be, so what? And you wouldn't have to get to the question of whether or not you harmed that person. In this instance, that there is a dichotomy between the gambling rules and wagering rules and the racing rules. And I think one of the main arguments will be that the rules of wagering in Kentucky and frankly everywhere is pretty clear that the parimutuel payouts are not affected at all by any later disqualification of a horse for anything after the stewards declare it official. Now, that was probably, I'm almost sure, that was a function of the technology at the time, right? I mean, for our younger listeners, account wagering and computer wagering is only you know, John, in our lifetime, it's only less than half of the time that we've been gambling, and the racing rules, it's only 1/10 of. So there was always a proof problem, and something had to be official, because at some point official was official, because otherwise you'd have to unpeel the onion and redo everything. So the racing rules are pretty clear. The wagering rules are pretty clear, you know, all throughout, that as far as the official wagering payouts go, they're final when a race is declared official. And I don't think that one of the lawsuits is brought against Churchill Downs. I don't think it's hard. I think it's hard to find that they have some duty to somehow turn back the clock and figure out who's owed money in case this happened. Racing rules are pretty clear. Once it's done, it's done. And that's not uncommon. That's not uncommon in a lot of financial transactions. You know, I mean, there's a reason why the deed on your house can't be undone once it's filed. You know, there's a reason. There's a need for you know, for finality. So I guess that would be the initial defense, that what happens to the purse money, what happens to the official placing in orders, really has nothing to do with the gambling or the wagering aspect of it. Now, a different question, and one that I tried to find, and I spoke to some people about a class action suit, would be the owners of these horses who won and with performance enhancing drugs, but were not disqualified, and what happens to the purse money. That's probably a different case. That's probably a stronger case, in my opinion. In my opinion, so I'm thinking back to the Service and Navarro cases. If it does come out that they're eventually found to have had a pattern, I think owners of horses who ran behind them can seek to have that money returned, even if the racing officials decide not to do so. So that's the first question. The second question is the burden of proof. I think typically you're right. I mean, there is the thing of, oh, so what? He would have won anyway, and that's in almost any endeavor, athletic endeavor. But I think the rules are pretty clear that if you're found to have used performance enhancing drugs in almost any endeavor, they reverse the results. Right. So, I don't know if they necessarily have to prove that but for the illegal medication he would have lost.
So would betamethasone qualify under the law as quote performance enhancing? It's my understanding a commonly used therapeutic medication that's banned on race day, but it's not a banned substance at all. It's a common substance, and it's not banned for as far as I've been able to research for its performance enhancing properties. It's banned for primarily safety reasons because it takes down inflammation and allows horses to run through conditions that they might not be able to run through, which that can be argued as performance enhancing in and of itself. I get that, but
right.
It's not technically classified as performance enhancer. Is that going to be an issue?
I don't think now remember, and one of the reasons when you read the lawsuits, they explain in great detail, how gambling works, and for people like us, or your listeners, we find that a little bit unnecessary, right? We know how it works. We live it. Remember, however, that the courts and judges and juries, don't necessarily know everything. So they have to be told everything. And I think and that's not a knock on them. They can't know everything. So you rely upon being told what they are. I think the fact that a substance is prohibited to run on will carry the day. I think that will be enough. I don't think you'll have to prove that it was that it caused the superhuman or super equine response. I think that it's banned is banned. I think.
Okay. Interesting.
And John, just to continue on that, I mean, you can take the position. I think Bob Baffert's people can take the position, and the owners can take the position of, we don't care about the wagering. We don't have a duty to the bettor. We don't have a duty to the gambler. I mean, I represented a thoroughbred owner and breeder many years ago who was a devout Mormon and found gambling to be abhorrent. Had no part in it. Wouldn't. And we know that there are many people in racing who express disdain for gambling. That's sometimes track management, sometimes owners, sometimes. I mean, there's a lot of crossover. A lot of people who do respect them, but I think they can take the position of, look, I ran my horse. I used the medication I used. I know what the penalties are. So be it. And I think the one lawsuit that, I'll live with the penalties. I'll live with the penalties. And the gambling is not one of them. It's not my concern. You see it in the NBA. I mean, up until recently, gambling on sports was largely illegal. But now you see it's common for, at the end of the game, for someone to dribble the ball out rather than score a basket and not go in. And he's or she are unconcerned about how that affects a gambler and is proud to say so. So I think you might see a defense that just says, look, I'm in the business of training horses and winning purses, and that's what I did, and I know what the penalties are, and I'm a big boy, and I'll take them. And the one lawsuit, the Matera lawsuit that was brought in Kentucky, goes through chapter and verse 36 violations. That cuts both ways. One, it proves that, yeah, this is a pattern. But it also proves that, hey, look, anybody who pays attention to this game knows that this barn has this history, and do with it what you may. There's a reason why bonds that win at a clip of 25, 30, 40% go off with odds on.
Let me ask you this: if you were defending the case for Baffert or a similar case, and the plaintiffs had been on record before this as saying they knew this guy was not playing clean, or had a history of this, or had a history of that, or they sometimes bet his horses because they felt that he had that history, would that be something that you would exploit to use against them and further what you just brought out?
Yes. I mean, it's among the handicapping tools that any serious handicapper uses. And when you see it most glaringly with people who try to do commentary, and they try to be judicious about it, and I give them credit, but they say things like, moving from one bond to another, and the first trainer was a wonderful horsewoman, a horseman, but the second guy wins a lot off the claim. They say that. Those are statistics that are literally published in the daily racing form. First off the claim, first in this bond. It's all in a mix. I mean, it's any morning line maker, will tell you that it goes into their assessment as to what the wagering odds will look like at the end of when the bell goes off. It's clearly a factor.
So the fact that Bob has a history of violations can actually be a double-edged sword, where it can actually help him in defense by saying, hey, everybody knows that I've got this history of violations and they should wager accordingly. It's not hidden. It's the information's technically out there.
Yeah, I think it's even, frankly, I think it's even stronger than that. Not that they should wager accordingly, but in fact they do. The case can be made that Medina Spirit wouldn't have been 9-1, but for it coming from Bob Baffert, who has a long history of winning the Derby, and a
lot of his horses, just automatically, like his maidens, whether they like him or not, or sometimes even money 6-5, just because it's him.
Right.
Right. I'm not saying that's he's doing anything he shouldn't, but he wins a lot of those races.
Right. Now, who that reflects terribly upon are the regulators. The regulators, whose job it is to and who in fact have the power to look into the patterns that are laid out by people who play horses as evidence of someone who is either over or close to the line. They have access to that information if they wanted to. So the lawsuit against Churchill Downs is interesting. One of the lawsuits includes Churchill Downs as a defendant. Right. And I don't know this for a fact, but if I were advising the New York Racing Association, it's something I might have taken into consideration as to whether or not to accept entries right now against someone who's a racetrack who ran the Kentucky Derby is being sued over. But as far as the gamblers go, it's very hard to indicate that you're not a professional, but a sophisticated gambler who spends a lot of time on this and who doesn't know which bonds have your reputation for running better than expected at times.
Well, what about the plaintiff who's not a savvy gambler, who just bets the Kentucky Derby and lost because he thought the playing field was level? How does that apply to them? Because all the plaintiffs are not the same. I'm sure some of them are sharp, professional, well-versed gamblers, but I don't know that all of them are.
Right. No. Well, clearly they're not, because they're seeking to represent the class. So right. So whether it's I think it's I forget which plaintiff says he uses a sophisticated algorithm that rivals Wall Street algorithms, or the person who picks up the newspaper once a day on Kentucky Derby Day and places a bet. They're both represented equally, and they both probably would claim to expect that the race would be run without the use of performance enhancing or banned medications, and that if it in fact was affected by that, or a horse did win who had a banned substance, that the bets would be reversed. However, as we've just disclosed, it's pretty clear in all the racing rules that that's not to be expected, in the wagering rules rather. That's not to be expected, and it's no secret to anybody who's been around a while. And gambling is a heavily regulated matter, and I think the states are free to put whatever rules around them that they want, as long as they're uniformly applied.
Interesting. Now, what happens to the poor guy who went to the Derby that year? Okay, bet 200 on Mandalore, lost, race was official, tore up his ticket, didn't use an ADW, didn't use anything, did everything right, followed the rules, took everything at face value, lost his money the same way as the plaintiffs, but has no ticket because he didn't bet with an ADW. He's just out of luck, tough luck, go home, pound sand.
Well, that's interesting, right? So, class action suits are used often in instances where you can't perfectly identify who was harmed. So, some class action suits that come to mind are a hamburger chain that issued coupons, and the coupons were virtually impossible to redeem.
Okay.
Free this, free that. But whenever you went to use it, it was. We've kind of all in the past we saw the airline frequent flyer mile model promise that you could go everywhere and anywhere, but whenever you went to try to use it, it was not permitted. Right?
It had to be Tuesday morning at 10:07 exactly, or you couldn't go. Right.
Right. New York to Florida through Denver. Congratulations. And class action suits were brought in that instance. And because of the nature of class action suits, the court is allowed to formulate almost any compensation scheme that makes sense. So there have been class action suits where you can't really identify, but it's largely. I mean, one of them comes to mind to me was in Puerto Rico, that the people of Puerto Rico, just residents of Puerto Rico, were overcharged through a illegal activity, overcharged for goods, and you couldn't go back and find out who they were. But the people who were sued, and the attorneys crafted sued the defendants and got a settlement, and they built a park in downtown San Juan with the money. So you could kind of craft it. So I mean, if they come to the conclusion that there was $158 million bet on the Derby, or I probably have that number wrong. I think that was the total handle for the day, but whatever it was bet on that race, and so much of it has to be redistributed, and they can identify who gets some of it. The balance they can put towards racing education or jockey welfare or free racing programs for people every Kentucky Derby Day, or you're free to craft almost any settlement that you wish.
Now, we all know, or at least anybody that's ever been involved in any kind of litigation knows, it's not fun. Okay, it's not fun to get sued, and it's not really fun to sue somebody. A lot of things become discoverable. A lot of things become just out there, so to speak, and it becomes costly. How much of a serious problem is this for a trainer like Bob Baffert? How high on his radar do you think this should be in comparison with everything else that he's fighting and going through right now? I mean, is this something that's a back burner thing, or not as serious, or can it be potentially devastating? I mean, what if I was Bob and you were my lawyer, what are you telling me right now?
Well, as we spoke of earlier, the real battle is having the class certified, and when you're sued, now the plaintiffs have the advantage of the law firm seeking to represent the class doing it on contingency. So it's unlikely that the lead plaintiffs have laid out any money. If they have, it's not been significant, and nor will it be, and nor will their recovery be significant compared to the recovery of the class. So again, think of this, as much as the people have laid out that, I bet this, that, or the other thing, and my $1,000 bet should have returned me 22,000. That sounds a lot. That's not insignificant. But if it's talking about the class of everybody who bet on the Kentucky Derby, it's really insignificant, correct? So the real battle for Bob Baffert right now, or anybody who's sued, is to pay the defense costs, which, unless you have an umbrella policy, most people don't have anybody to pick that up for them. So the defense costs will be significant. And if in fact the class is certified, as I said before, class certification, almost always leads to a settlement, because the possibility of whopping back-breaking damages is there. And when you add to it the RICO thing, which calls for attorneys, the loser to pay attorney's fees and to have treble damages, meaning they're tripled, it forces a settlement very quickly.
Okay. Can the case go on legally with only certain elements allowed? Can they say, well, this is not a RICO case, but it is a class case and we're going to go forward this way? Or is it kind of the whole enchilada or nothing? How does that play out?
Well, that's a difficult question. When the class is certified, after the class, or if the class is certified, again, it's far from a certainty that it will be. You can, not every class action suit that's brought results in a certified class. So that battle still to be had. But it would be after that the question of whether or not it was a RICO case met the requirements of RICO would be determined.
So then the case could technically become a class action case, continue, but the RICO portion of it not.
Correct.
Interesting.
Correct.
Interesting. What kind of precedents are on the line for horse racing here?
Well, I mean, I would, if I were defending this case, and again, I'm not, so I haven't done the rules. I haven't done the work on this necessary, so I don't presuppose. But I think the precedent is bigger than just for racing. I mean, certainly racing relies on gambling, but a lot of sports have gambling involved in it now too. And I think a case can be made that it's a heavily regulated industry, that the wagering is regulated separately from the participation in the actual sport. Jockeys don't need to be concerned about the wagering matters. The owners don't need to be worried about wagering matters, and they're governed by two separate sets of rules. And that, it's absolutely necessary that those rules be uniform and that those rules be followed strictly, and to undo them afterwards, would make the business, the wagering portion of the business, unsustainable. And that the legislatures in different states, by allowing what has previously been a vice and allowing it only under strictly regulated conditions, have preempted any other laws from applying to it. So sort of it's once, at least on the wagering side, once final is final. I mean, that would be the argument that I think would be strongest.
Interesting. Now, right now, I guess until the case is either certified a class action or not, everything is up in the air. Am I correct? It's kind of like unknown waters right now.
Correct.
Okay. Let's say it does not get class action, and do all of them become class action, or will each one be decided separately if it's going to be class action?
Well, that's another complicated matter. It's not uncommon for a number.
You, Bill.
Yeah, that's right. That's right. It's not uncommon for multiple class actions to be brought for the same matter, and at some point, the federal courts will be asked, presumably by the defendants, to consolidate all of them into one action. Okay. And as a matter of fact, there's a specific section for not just class actions, for anything that's brought in multi-districts to be consolidated in one place, because the cost of defending yourself in 50 different states or endless numbers of local jurisdictions can be crippling before any adjudication of liability.
So it's going to be probably all of them are going to be class action certified, or none of them are going to be class action certified?
They'll be consolidated. If it before it goes forward, I expect it would be consolidated into one action. Someone will be appointed to represent the class, and then it will be their job to see whether a class can be certified.
Now, the interesting thing is, well, one of many interesting things, if it doesn't get class certified, if they say no, not a class action suit, does the then lack of a better term, momentum or pendulum swing in the defendant's favor significantly, or not really?
Well, it depends on why it would be dismissed. If it were dismissed simply because a class action is not the right way to go,
right,
then each person is free to bring their own lawsuit.
Right.
If, on the other hand, it's dismissed because it's found, like we spoke a little earlier, that the racing rules, that the wagering rules are sacrosanct, and there's really no duty on the part of any trainer or owner to any gambler, collectively or individually, and then that would be already decided, and there'd be no suit to go forward with anywhere.
Is that really possible? I mean, that sounds like a tough pill to swallow for me. And I get it, but I would have a hard time accepting. Obviously, you have to accept what the judge in the court says, but I would have a hard time with the court saying, you know what, trainer doesn't have any duty to any better at all. I would be like, well, somebody does. The racetrack does. Somebody's got to be accountable for that. No? Well,
I mean, the answer would be that it's somebody other than the defendants. Okay. Okay. I mean, it's not. You don't have to solve the crime. You just have to say it's not me. Gotcha. So there's. I mean, I don't know. I guess. I guess if you put out rules that were so opaque or so inscrutable that it said, you bet your money and we'll decide whether we give you anything, I guess you could play it in a game like that. Most people won't, but I think the wagering rules have been laid out pretty clearly, and it I mean, if the first thing I think anybody who takes a novice to the racetrack would hear about would be the first question anybody would ask, but hey, that horse was disqualified. Do I now get paid? And the answer would always be right away, no. Once it's official, it's official. That's why they put it up on the lights on the board and they pay the money. Right. So I can see them saying that somebody may have an obligation to make sure things are on the level. That may be a state regulator. It may be a racetrack operator. It may be the stewards, but it's certainly not any individual trainer or owner.
Interesting. That's the defense that I didn't even think would come into play. What kind of time frame would a case like this?
Forever. This is not something that's if it plays out is going to be determined anytime soon. This is a.
What about the class action status? Does that take a long time as well?
That can take a while as well. I mean, in layman's terms, not in legal terms, but yes, that's going to be a pitched battle. It's going to be particularly, I would think. I don't know the wherewithal of the individual owners but certainly Churchill Downs is a public company. It's going to defend itself to the hilt. There's no question about that.
Yeah, that's what I thought. I was speaking to somebody yesterday, and I said, I can't imagine Churchill Downs ever coming to a voluntary settlement in a matter like this in the Kentucky Derby. I just can't see it, you know.
Well, it's all in the amount, right? I mean, it's, sure. I mean, you could justify any expenditure to that's reasonable to keep the reputation of the Kentucky Derby intact, to keep your reputation with bettors intact, to take a stand for race integrity.
I would argue that any settlement by Churchill Downs voluntarily hurts the integrity of the Kentucky Derby.
It might. I mean, there have been cases where ADWs have refunded money on various things, right? I mean,
yeah, and that's goodwill. That's different.
right.
I would applaud any ADW that did anything like that in any kind of situation, not just this, but in any kind of situation where, the bettor was put at a disadvantage through no fault of their own. I've heard of cases where, ADWs have shown goodwill on horrible call situations by stewards and things like that. Not often, but I've heard of it. But, this is a case where you're talking about Churchill Downs, who, lack of a better term, owns the Derby, which is supposed to be the greatest 2 minutes in sports. And I just got a hard time seeing them conceding anything about that race not being, handled properly and coming to any kind of compromise settlement. I could be wrong. I don't know. But I think anything that they did that admitted or inferred or implied any type of shortcoming on their part in making sure everything was done properly
Right.
is tough for me to get there.
Well, in a lot of matters like this, though, John, that is so large, insurance plays a role, and
Right.
and the insured party doesn't always have the say
Absolutely.
in what's in the best interest of the person who has to pay it, which is the insurer. So,
Right.
I mean, this could result in, in any number of, if it's class certified, it could result in any number of settlements. And, the class action suits always portend back-breaking, bankrupting penalties or judgments, but they rarely do, because that's always becomes an incentive to settle. At the end of the day, sanity prevails. So.
Right, and interesting, but is it possible that the numbers in this case are just too big to even get there? I mean, you're talking about essentially one trainer and one owner. If it all falls down on them, I mean, and it can be as large as you're saying. I mean, does it run the risk of being just a number that's just too big to get a voluntary settlement?
Well, that's a different question, and one that I'm glad you brought up, right? Apart from the devastating consequences that may occur to anybody who's a defendant, and you don't wish that on any worst enemy, right? Because, as you said, it's not fun, it's time consuming, it's financially draining, it's everything. Apart from the discussion that we just had about the wagering, what does it do to the incentive or the fear of owning a racehorse? I mean, up until now, let's face it, we've let owners pretty much skate on misconduct of their trainers.
100%.
And I don't think it's any secret that some big people in racing, have employed trainers who've had spotty records and who've had violations. I mean, that the list of owners that John Service and Jorge Navarro had.
Racing Service.
I'm sorry?
Racing Service.
I'm sorry, yes, excuse me. Yeah, I'm sorry. But their list of owners was a pretty significant group. And to this day, apart from returning the purses that were redistributed, they haven't suffered any consequences. So this might be the first time where someone says, gee, I like owning a racehorse. It's fun. It's always something I've always wanted to do. I like doing it in partnership with my friends. I like doing it. I like doing it as an adjunct. I like to support the sport, but I don't really want to open myself up to any liability. And so I think it's important for the racing game to make sure that owners are somewhat shielded if you're going to have owners.
Interesting. Now you mentioned something earlier that I know is true. When you get out of the racing environment, okay, you move into the courtroom and you're dealing with people that don't understand the game, okay, and they have to be, like you said, told everything. Is there a danger in that bettors suing over a lost wager are just frowned upon in a courtroom as like, and I'm not saying this is the case at all. I'm just saying that is it possible that they can be perceived as, oh, they're gamblers, they're sore losers, they're crybabies, or whatever, because they don't really understand all that's involved in racing. Is there a danger of that at all? And I'll tell you why I bring it up, and you might be familiar with this. Years and years ago, when we were working at Saratoga as mutual clerks, okay, there was, I believe, a school teacher who went short a lot of money, okay? He had a system. He was one of those summer workers, and, you know, every year he used to make big show bets. And you know, he didn't have the money. He would just punch the tickets, make big show bets. And if he happened to lose one, he would just double up and double up. And he would make a little extra money every summer, apparently doing that, you know? And eventually he went bad one day and just, you know, doubled up and doubled up and doubled
Right.
doubled up. And I believe the story was they caught the guy right after the last race trying to drop down from one of the catwalks in Saratoga to run out of there. And he didn't make it. And NYRA at the time, I believe, tried to have him prosecuted. And the case ultimately was dismissed because what I had heard, and I didn't look up the case, and I don't know this to be accurate, but I remember guys that were on the union board were talking about it, and you know, they had no reason to lie, and they knew the story a lot better than I did. And you may know the story, but I heard the case was dismissed because the judge was like, your system is ridiculous. It almost invites people to steal, gamble, and bet money out of their boxes that they don't even have. And the case wound up getting dismissed, and they made a lot of changes at NYRA after that, along those lines. And you know as well as I do, there was a time that mutual clerks pretty much had a free hand betting whatever they wanted to bet, whether they had the money or not, and only used to have to count out their boxes once a week, if you remember
Correct.
like that.
Right.
So if I was theoretically short $2,000 or $3,000 in my box, and I counted out Wednesday and you counted out on Thursday, it was routine practice. I would come to you on Wednesday and say, hey, Bill, give me 3,000 so I can balance out tonight. You'd give me the 3,000, I'd balance out. Next day, Thursday, I'd open up. As soon as I sold $3,000 worth of tickets, I'd give it back to you. My draw was short 3,000. And that was a vicious cycle that several clerks ran for months, I think some for years, never really having to balance because everybody counted out on different days. Getting back to this story, do they run that kind of risk of just because people don't understand the racetrack, that they're going to just look at them as, hey, gamblers doing over a lost bet?
I mean, you're certainly right. That was a flawed system, and there's great debate at the time and to this day in my mind whether it was a flawed system by accident or on purpose. You know,
that's another interesting question.
Yeah.
I believe it was on purpose. But
yeah, I do too. I think
on the show that we could talk about it. Those are some unbelievable stories.
Right. But, I think management at a time had a desire to shed itself of high-paid union employees and giving people with a gambling problem enough rope to hang themselves served kind of two purposes at once. But yes, I mean certainly in well, you know it. If you talk about betting horses, it's also in many times in the general public it's looked upon as a frivolous a frivolous activity and not one to be taken seriously. And if it is taken seriously, it's kind of silly. And so, yeah, you do run the risk of someone saying, yeah, look, we kind of assume that everybody's doing everything they can to get close to the line. Someone's going to go over the line. The regulators can't catch it right away because of the nature of medication and testing. And, and therefore you made your bet and the rules. That's the sophisticated approach. The second approach, as you said, is the total dismissiveness of, I don't want to hear from gamblers in my court. I think that's probably a bias that once existed. I don't think it is right now. I think depending upon who you get, of course, but I think gambling is seen now as a more reputable activity. And I guess there was even a day when people thought, when you go back to before the SEC, anybody who invested in stocks was considered to be a fool. So I mean, there's probably a better awareness of it now, but that bias still exists.
If you had a bet, time frame that this is resolved and the Baffert better litigation is over, what would be your best guess? 2 years, 1 year, 3 years?
John, I'm not qualified to give that. I mean, the court system moves slowly, depending upon the resolve. I mean, all the firms representing the plaintiffs in these cases are reputable firms who've done this before. So they're well heeled. They're not gonna be waited out. And I guess depending upon how deep the pockets are, or whether there's any insurance on the part of the defendants, could lead to a settlement before. But again, the real battle is going to be over certification, and that's.
When they battle for that, is that something that the attorneys file briefs and motions on, and
yes,
that, or does the court just decide based on the merits of the actual lawsuits that have been filed?
No, it's very heavily litigated between the parties.
Okay, interesting. So that's so common sense would tell me that the plaintiff attorneys, the firms that took this case, know that they've got that legal battle. They've got a lot of work to do. They've got to feel that they've got a decent shot if they're signing on for this, because if they're not getting paid up front and it's all contingent, they've got to think they've got legs, no?
It's hard to handicap. I mean, they're experienced attorneys in class action suits, so I'm sure they've done their homework. But that's not to say that class certification doesn't get denied often. So it's I would say that the people involved, it's far from being frivolous. The people involved have done this before and have some level of confidence.
Is it the kind of case that the defendant can file some type of motion for summary judgment or motion for dismissal or find some grounds to maybe dispose of it earlier? I mean, do you anticipate something like that coming from the defendant?
I think the defendants will likely join together to fight the class certification.
Okay.
Once the class is certified, if it is certified, then there'll be an opportunity on the part of each individual defendant to say, yeah, I don't know what they did, but I didn't do anything wrong. There'll be part for divergence. There'll be time where they can diverge later on. But initially, I think all the efforts will be in fighting class certification.
What's the next move that's going to happen?
That's interesting. I don't know what the next step will be. The next step will probably be
normally that like the defendant has to file some kind of an answer.
Right. And the defendants will acknowledge that they've been served. We'll probably ask one court to grab hold of all the suits that are similar so that it's consolidated. Okay. And then ask for a schedule, to make their arguments that class certification shouldn't apply.
Will all that be public record and stuff that people can follow and read and see?
Yes. Yep.
So it's all really essentially becomes an open book.
Yeah, I mean, you can request that things be held, be redacted, or things but there doesn't seem to be much reason for it in this case. It's hard to find a reason why you would.
Now I know discovery, which is the process of finding out information about both sides, is usually a liberal process, correct? Does that work both ways? Does the defendant get to find out a lot of information about the plaintiff and vice versa, or is it just one way? The defendant pretty much is exposed and the plaintiff is not.
No, it clearly works both ways. It clearly works both ways, but it has to be relevant to what your case is. I mean, it's sometimes a lot of people think of discovery as being the National Enquirer going through all your dirty laundry. It's not really that. It's limited to what the question. One thing that came to my mind was, and I forget which of the cases it was, said that they used a complicated or sophisticated computer model to make their bets, which, for guys like you and I, it made me kind of smile a little bit. We kind of think that we're the sophisticated computer model, right? When you handicap yourself. But I would expect that you might ask for discovery of what goes into that and whether or not a trainer's win history in particular races goes into it. You'd make the case that it was already factored in, and that,
I would say that was relevant. I mean,
right. I mean, how many of the bets on the runner-up, including mine, on the runner-up were based upon, Brad Cox wins a lot of races. He wins big races. I don't think he should be 26-1. Right? I mean, so it'll be interesting to see whether that's in the algorithm, which would say, well, you got exactly what your algorithm pushed out there. Pushed out.
Right. Very, very interesting case, and far from clear cut and shut and dry. I mean, it's a based on the way you're explaining it to me, it's a complicated case with a lot of facets and a lot of different arguments that are going to need to be hashed out.
Yeah, and the fastest path, to defending the case, wouldn't necessarily be a good one for the people sued, but it would for the defendants. But it would be, in fact, look, I don't involve myself in the gambling. It's not my job. My job is to put a horse out there who's in good shape to go a mile and a quarter on the first Saturday in May. I did that. If I did it with a banned substance, then there's penalties for that. I know what those penalties are, and I'm a big boy, and I'll either fight them or I'll take them. But the wagering is a whole different thing, and I think that's the hardest part of this case, is that it's probably been, 300 years worth of precedent, certainly more than 100 years in this country, as to the wagering being completely separating from the purse distribution. And this was played out in the Kentucky Derby in 1968, right? I mean, this happened.
Absolutely.
So I now where that certainly doesn't do any favors to the sport, and it doesn't do any favors to the defendant's reputation. I think it is the defense. The defense is, look up the rules of wagering. Go speak to the Kentucky Wagering Board, whatever. I'm not 100% sure what the actual name of that is, but go speak to or if you bet it in New York, look for the New York State Gaming Commission and ask them what your rights are, and they'll tell you pretty clearly you have none. And so why are you bothering me about that? I mean, and so that's an unpopular defense as far as sounding coarse, but that is the defense. And John, this goes back, and I you and I are active on Twitter. And we see people handicapped in public now, which is something that, we never really saw before. But, so many people express distaste at riders' choice of rides, because it's no secret that in New York, on the grass, riders now tend to clutch and grab more than they did. And people rightfully say, gee, I expected so-and-so to battle for the lead, And you know what the short answer is? The short answer is that the riders don't owe you or I a duty to act the way we think they should. That's, if they decided to coming from off the pace was the best way to go, they don't owe us that duty. And I think the same can be said for trainers or owners. They put out a horse that's in the best shape to run that day, and if they had a violation, they know what the penalties are.
True. Interesting. Interesting.
I mean, it's a sympathetic case from an owner's standpoint to say, look, I own a racehorse. I employed a trainer who's in good standing with the states where we race, and he or she is licensed. And I'm a big boy, and if my horse comes back, with a banned substance, I know that happens, and I'll give back the purse. It's a different thing to say, and you might even, if they had information that the owner bet the horse, you might even expect him or her to say, and I'll get back my winning bet, But nobody, when they buy a racehorse, expects to be hit for the redistribution of the handle on one of the heaviest bet races of all time, right? That's a risk that's way too far, in my opinion, for them.
Agreed. Now, and I don't want to take too much of your time on this, but we've gone on for a while. But one last point. Assuming that Otamax, which is what contained the betamethasone, was used on the horse in the exact manner that's been reported, and that's Bob's statement. Okay. Horse had a rash, rubbed some of this cream on it. The fact that, and I'm just taking an adversarial role from the defendant. Okay. The fact that I've got other violations where I've done this is because you've got different jurisdictions, horses metabolize different incidences, contamination, different things happen. Those matters have all been adjudicated. Okay. This particular incident is of itself and was not meant to game the system. It was not, quote, what we would consider a performance enhancing drug. It was used to treat this, and it somehow tested positive under the watchful eye of Churchill Downs, who supposedly had the strictest protocols for the Derby ever this year. So it happened. It was one incident. It wasn't done to game the system. It was unfortunate for me, for the owner, for the bettors, for everybody, for the sport, but it's not a RICO conspiracy, and wasn't done to defraud any better or cheat any better. Is that a defense as well? Because that's a logical argument to me in a courtroom, as are some of the ones that the plaintiffs have. So I'm not, I'm not saying that they don't, but isn't that also a logical argument towards, hey, what are we doing here?
Right. I mean, the defense is, in addition to, I don't have anything to do with gambling, and I don't owe anybody a duty. The defense is that this is a hyper technical area of the law that the state legislatures in the racing states have delegated have dedicated to a governing body to handle, and an administrative body to handle, and their decisions are final and are to be determined, and their power is somewhat limited. And among the penalties that they have is to redistribute the purse. And if they want to do that and they want to give me my due process, then I'll live with that. But there's really no, I mean, clearly, when you have an administrative decision, it's very hard to overturn it, because the government has said this is their area, they'll handle it. They should not be second guessed, which is why all the lawsuits that were brought about the Kentucky Derby 2 years ago, where the stewards made the decision, were dismissed. The court said, don't we have an administrative agency that handles this sort of thing? And the answer was, yes, we do. And the administrative agency said the decision of the stewards is final and can't be overturned. And you know, Gary West spent a lot of money on trying to overturn that steward's decision, and he was rebuffed because the court said this is not our area. You know, this is the area of the administration that handles it, and unless they did something that's so out of bounds, we're not going to second guess them. So I think the defense would be, yeah, this is properly handled. It's a determination that a horse tested positive for a banned substance, and it's handled at the administrative level, and their decisions are what rules. You know, and that's as far as it should go. Yes, that clearly would be among the defenses.
You know, interesting case, and I still, again, layman and understood that everybody wants to be first, and everybody wants to, you know, draw that first shot and get in line and do everything. I just think that a lot of premature action went on in this case prior to the split sample. Now, if we can, I apologize.
Familiar ring.
That's my phone rings. I apologize. One last thing, another topic. The split sample has not been sent in yet. Okay. The rule in Kentucky, and I read it for myself. I wrote a little bit about it. It says the trainers got 3 days to request in writing split sample. That was done. It then says the split sample will be sent in as expeditiously as possible. Now, you and I both know as expeditiously as possible is not a specific time frame, 30 days, 60 days, 90 days. What are your thoughts on that? Because I think that creates a problem because of the actions that NYRA and Churchill Downs took. I think they kind of took away the urgency from the trainer to send it in, because theoretically, you've already banned me from running at both of your racetracks, okay? Before the split sample came in, okay? Before I sent it in, you've already agitated the matter while I'm in the process of exhausting the rights that you afford me to defend myself. So I'm ready to send it in as, quote, expeditiously as possible. But what happens if it comes back negative? Oops, we're sorry. You already hurt me. I mean, so you see where I'm going? I mean, I think that, you know, while the popular decision, because everybody is up in arms over this happening, may have been, hey, we're going to show we're doing something and we're being proactive, they kind of went around their own rule, and I think created a little bit of a problem.
Well, I mean, three things, right? Three thoughts come to mind. You know, one, Bill Mott spent an endless amount of time and a fortune in legal fees. Not that I begrudge anyone legal fees. Everyone should spend as much legal fees as they need to, you know, all the time. Right, and then some. But he spent a lot of money defending his good name, and was denied even having the second sample. The split sample had deteriorated and disappeared. Right. And to show you the power that administrative agencies have, the court said, well, we don't care. If the administrative agency is happy with what they have the power to do it. We don't think they did anything really wrong. They decided that even without the split sample, they were convinced, and therefore his suspension stands. So that's a level that you have. As far as NYRA's decision, as I said before, you know, it may have been ultra conservative in their mind because there were lawsuits out there. It may have been, as they stated, that they believed that, you know, the integrity of racing demanded it, and that it's high up there. It may have been that, you know, one general rule: if you wind up on Saturday Night Live being made fun of, you're not necessarily welcome in my establishment. You know, and they do have that power. So they do have the power to exclude people, and that's been pretty tested too. So whether it was wise or not is not really the question. They have the power to do it, and they did it. And
would they have done it had Medina Spirit won the Preakness?
That's again another one of those questions. You know, maybe not. You know, but I'm sure I'm sure the publicity surrounding both Bob Baffert's initial statements and then the secondary statements then being made fun of in the general public and the prospect of lawsuits probably just added up to enough that they made a business decision and their stated statement that they felt that integrity was somewhat questioned. But John, I think one thing to think about when you look at these lawsuits, and there's a lot of ire being brought at Bob Baffert, and I don't know Bob, I know you do. I think when you look at those lawsuits, the ire is really being brought down on the inability of the sport to police itself, or the inability of the public administrative agencies who are charged with governing the sport failing to do so. I mean, when you look at it, particularly the Matera suit, you know, it's not so angry over Medina Spirit. It's angry over 14 years or 15 years worth of perceived inaction on the part of parties who have the power. And I think all of us who follow the game every day and know of a lot of hardworking people who've been driven out of the game, owners and trainers, by their refusal to get close or over the line on medication issues, but yet have seen that no real action has been taken. I mean, remember the Service and Navarro cases weren't really brought by anybody racing related, you know. So I think the anger that you're seeing in these suits, and I think if you spoke to the plaintiffs, you know, they might have an axe to grind with Bob Baffert in particular. I don't think so. I think their axe to grind is with the game, or with the people who are charged with protecting the integrity failing in their eyes.
And I think most people in the sport share that frustration. Okay, and I think that it's without question that as an industry we have failed to police ourselves, and it's one of the reasons why I welcome and support HISA. A lot of people don't. A lot of people are reluctant to have that much, you know, governmental involvement in the running of horse racing. But my thought is this: we failed. Somebody else has to do it, you know, and that's why I'm hoping HISA is successful in doing that and at least starting that. And I think that might be another argument that comes up in this case, going towards what you said, where you have plaintiffs that are frustrated with 14 or 15 years or more. I mean, if you go back to the days of, you know, the allegations against Oscar Barrera, who was never, quote, technically caught doing anything wrong. And you remember what his barn looked like. His windows were spray painted black. You couldn't even see in it.
Right.
You know, but he was technically never caught doing what he was suspected of doing. So it goes back even longer than that. So yeah, there's that frustration. But I think a dangerous area that people fall into is because the general public and consensus may have been correct about Jorge Navarro and Jason Service. It doesn't mean that they're correct about everybody that wins at a high percentage. And it doesn't mean that somebody who has a betamethasone positive is using stuff like that SG-1000 or whatever it is that those guys were allegedly using. I'm not even sure what it's called. But there are differences. And while we all share those frustrations and we all want a clean, level playing field, and one of the things I want is no race day drugs. You know, I'm of the old school belief that if your horse needs drugs to run, he should probably get some rest in the barn. It's just what I believe. Is that real, practical, or whatever? It's matter of opinion. But I think you run a dangerous area when you loop everybody together and assume because, yeah, we were right about, you know, Navarro and Service, so everybody else we think is cheating, we're right about them too. And I don't think that's the case. I think that There are many people that circumvent the rules and do things in this game and fly completely under the radar because they don't do it at 30 or 40%. They do it 3 or 4 times a year and nobody's any the wiser. And they're putting it over on everybody because they're cashing tickets and making scores. And I just think it's dangerous when, Saturday Night Live is deciding who the cheaters in this sport are, or social media is deciding who the cheaters are and who should or should not be allowed to participate in horse racing. I think we need a little better criteria than that, in my opinion.
Yeah, obviously. I mean, but I think is that there's always something that's a boiling point or a trigger point. And it's, if we could define what that would be, we'd all be seers. But this seems to have lit some anger that maybe wasn't there at other times.
Well, it's the Kentucky Derby. It's a very, very high profile guy who's been, quote, the face of racing for quite a while and has had success. That's really, I mean, if you take away all the allegations, his success is unparalleled by anybody in the sport.
Right, but I think, John, I mean, to be fair, we've lived through a succession of people who were super successful, and it turned out not to be legitimate. Lance Armstrong comes to mind.
Right.
The baseball hitters of the 80s come to mind.
Right.
So I think you have a public that's conditioned, for whatever reason, Baffert's prominence, this year has given the sport, in the views of the non-racing fan, a bad look, and I don't think he was helped by the first comments he had. Now, that may have been he was genuinely hurt and he was a little surprised by it, and that there all could be reasons for that. But I don't think it went over as planned. I mean, I don't think anyone really believes that people are trying to cancel Bob Baffert. I don't really think somebody said that. I don't think that was taken well. And again, it's never a good idea to come to the attention of the public for something bad. So
no, it never is, and it's an unfortunate thing for the game, and yeah. No, I get it. I get it. I think we all do, and hopefully, some good will come out of it. I think that HISA is a positive. I'm optimistic it's going to work better than a lot of people that are against it say it's going to work. I'm cautiously optimistic about that, and we'll see. We'll see how things play out. I have a feeling, and I don't know anything that anybody else doesn't know, probably less than a lot of people know, but I have a feeling we don't know all the facts and details around the Medina Spirit situation yet. I think there'll be a lot more that comes out about that and what happened and what didn't happen, and I think it's going to be interesting.
Yeah, I thought the horse acquitted himself and ran hard in the Preakness, and I was happy to see that. I think for racing, it was probably best that he wasn't going for a Triple Crown right now. Again, because of the controversy surrounding it. I was also glad that he didn't run so poorly as to solidify in people's minds that it was his performance was only due to a banned substance. So.
Right. No, I thought he ran under the circumstances. I thought he ran a good race. They ran 46 to the half. He was hounded all the way by another quality horse, and he did run third. He didn't just pack it in and quit. And it's a lot of irony in the case, because these bettors that are so incensed at Bob and have such ire at Bob, most of them say the same things about Brad Cox, the guy who they're fighting to get put up because, well, this time they bet on Brad Cox, instead of Bob. But most of them, not all, most of them have the same things to say about Brad Cox that they do about Bob Baffert.
Yeah, well, it would be interesting to see what that algorithm on the computer selection thing that one of the plaintiffs uses says about that. That's what I was implying earlier.
Yeah, no, I would love to see that, and I know a little bit about the CAW players and the algorithms, so I would definitely like to see how they plug that information into an algorithm and what exactly they use to program that. But
I mean, there has been a pugnaciousness though about the positives. There seems to be no stepping back. So like when Bill Mott had his positive, he was like, I can't believe this happened. This has got to be a mistake. I'll take the penalty if it's legitimate, but it's not legitimate, so I'm going to fight it tooth and nail.
Right.
Sometimes you get the feeling that people who've had a lot of positives and have fought them all and have managed to win them all, it builds up anger in people because the feeling is that it's not a legitimate, it's not as heartfelt a surprise as maybe it was with so again, I mean, I think the if you could go back in time, the stance after the Kentucky Derby and the positive came out, had it been a little different, maybe you wouldn't have had this. It's hard to say. But
no, I agree with that, and I think if Bob was here, he would agree with it as well. I mean, I don't speak for him by any means, but I would think he would agree with most of that. I think he said as much. Interesting. Let's see how it plays out. I can't thank you enough for coming on and talking about this. A lot of great insight. Definitely enlightened me to a lot of aspects of the case that I didn't even realize were going to come into play. It's an interesting battle that's on the table, I think, for sure. And I think it's got a lot of ramifications for horse racing if it goes forward and doesn't get resolved quickly. I think the ramifications for racing going forward are significant.
Yeah, and I think that'll be a consideration, when and if a judge needs to make a decision on this as to whether or not the administrative agencies who are specifically charged with governing this sort of thing are the best forum for it rather than the general courts.
Will the fact that the Horse Racing Safety and Integrity Act was passed and is now coming into play possibly affect the judge's decision by saying, well, maybe we would have got involved in this, but now we've got HISA, federal, governing body that's going to handle all this going forward. We'll just, leave it to them to work this stuff out going forward. Is that a possible punt by the court system?
I don't think so, John. I think I have to think off the top of my head, and I don't really want to speculate as to which side would use that better. But but just as a general rule, these type of things are left to the administrative agency charged with implementing the rules and regulations, and judges are less likely to get involved in that. So
interesting. Hey, Bill, I'm assuming you're up at Saratoga?
I am up in Saratoga, and I can report happily Saratoga is alive and well.
Okay.
And that the town is back open. Everybody's out. The weather's beautiful. The scenery is beautiful. There's just an absolute, resurgence of almost everything.
Is there that pre-August, well now July, that pre-Saratoga meet excitement in the air yet?
It's not here yet, but it's getting here. I mean, the restaurants are packed, and the Oklahoma surface has been redone, and it's I don't know when the barn's open, but it's soon, and
people start shipping in very soon, correct?
Right, and yeah, I think I think whether it be at the track itself or just in town, I think it's going to be a very successful meeting for people here. I think there's a pent up desire to be here. And
What about fans? Well, fans.
I saw something today that they're selling tickets. I think I saw that just before we came on.
Yeah, right. Soon, pretty soon.
And so I mean, make your plans to get up here if you can.
Yeah, I'm probably going to come up. I'm thinking about, I usually come up for about 10 days and I usually do like a Travers week. I'm thinking this year about maybe changing it up and coming for Whitney week, but I probably won't. I usually stick to my routine, and I'll come up for like 10 days and be there through the Travers.
Well, I will say the Preakness was a delightful experience this year. They did a great job. As much as I like the fun and the crowds, it was nice to be one where it was, mostly racing fans only, and that was fun. And they did a great job. And my friend Peter Prosher won a race with Paradise Farms. So we were in the winner's circle. It was nice. It was a great experience. It really was kind of good to be back in a racing crowd again.
Absolutely. Bill,
thanks, John.
Pleasure chatting with you. Always learn something. You bring a lot to the table. Lot of knowledge, a lot of years of experience. And I just enjoy your company. I enjoy catching up with you. We go back a long way. So
same
thanks
here.
for coming on, and thanks for your insight, man.
My pleasure, John. Thank you.
All righty, ciao.
Has taken the lead, and it's a vintage performance by Vino Rosso.
Nobody does it better.